The Thompson Rotors here in 202 Parkside office, and across the street is the loft, which they put the fence line and also the studding for the frame for the fence line, so they can put the fence posts and fencing back up. Bring it to the original original guidance, original hoping now loft can be updated. Now let's go on Wyoming Supreme Court. Wyoming Supreme Court. Let's get an update on that. Wyoming Supreme Court, April 15, 2019. Gibson versus State. Minners versus Minners, family law. Gibson versus State is civil rights, constitutional law, criminal law, April 15, 2019. New on verdict, legal analysis and commentary. Bypassing the Constitution. Texas legislator considers bill to add burdens to pregnant teens. SMU Dating School of Law professor John L. Grossman comments on the bill under consideration of Texas. Legislative Texas legislator that would require appointment of an attorney and item to represent an unburdened child during a judicial bypass proceeding for an abortion for pregnant minor. Grossman describes the legal background and explains why the bill is both unconstitutional and unwise. Wyoming Supreme Court opinions. Gibson versus State, citation 2019, Wyoming 40, April 12, 2019. Judge Kate M. Fox, civil areas of law, civil rights, constitutional law, and criminal law. Supreme Court affirmed defendant's conviction of one count of possession of intent of delivery marijuana, holding that district court did not err denying defense motions to suppress evidence. On appeal, defendant argued that the district court erred in denying in his motion to suppress evidence obtained after traffic stop, asserting that the stop error pretext should cause the court reevaluation whether a dog sniff or the exterior vehicle require the right legal framework under the Wyoming Constitution and the U.S. Constitution. Supreme Court affirmed holding defendant failed to present cogent argument under the Wyoming Constitution on appeal. Minors versus Minors, citation 2019, Wyoming 39, April 12, 2019. Judge Coots, areas of law, family law. Supreme Court affirmed the order of district court enforcing the terms of Pallett's divorce decree of request of late ex-husband's state, holding there was no error in district court's decision. On appeal, Pallett argued that the district court erred. District court erred decision. On appeal, Pallett argued the district court erred by modifying the terms of divorce settlement agreement and divorce decree, erred in the failing to apply latches, erred to conclude that the Pallett was not entitled to storage fees or mortgage considerations. Supreme Court from holding the district court correctly determined that the divorce agreement merged in the divorce decree cannot be modified by oral agreements of the parties. The action of Acton 406 P3D 1279 Wyoming 2017 is overhauled because of the statutes and states otherwise. Appellate failed to demonstrate they should be entitled to relief from the decree under Wyoming R. Civil P.60B 3. Number 3. Appellate would not use the doctrine of laches to prevent enforcement of a judgment. Number 4. The district court properly held that the appellate was not entitled to storage fees or mortgage considerations. Nebraska Supreme Court, 2019, April 15, 2019. State versus Gibson, criminal law. Baines, family law, real estate, property law. Glaines Board, equalization, city of Omaha. Government administration law, real estate, property law. Barra-Hanson, Nebraska Department of Health, Human Services, Labor, and Employment Law. New verdict bypassing. Nebraska Supreme Court, State versus Gibson, citation 302, Nebraska 833, opinion date April 12, 2019, Judge Furneberg, area of law is criminal law. The Supreme Court reversed the decision of the Court of Appeals, reversing the district court imposition in the sentence of 5 years, probate with 100-day jail time, and a condition of probation on defendant's conviction of attempting sexual assault on child on the grounds on the sentence was excessive, holding the sentence was unreasonable or clearly against conscience of evidence. Princeton Chain's investigation report then defendant believed that the child 18 years old. Further, defendant has no criminal record. The state appealed the sentence and argued that the excessive lenient involved inappropriate considerations a relevant factor. Court of Appeals argued that the state Supreme Court holding, although the sentence in district court was not unreasonable intent declared against justice and conscience, evidence, and reason. This is Bain versus Bain, citation 302, Nebraska 858, April 12, 2019, Judge Frenenberg, family law, real estate, and property law, areas of law. Ended declaratory judgment action with ex-husband sought the declaration that was entitled one half of the proceedings of the home awarded ex-wife. In the divorce decree sold 2 years later, and then the wife decided to remarry. The Supreme Court affirmed the judgment of the district court, declaring that the wife entirely refinanced the house, and therefore the husband entitled one half of proceedings of its later sale. Holding the district court judgment was correct. A provision of disclosure decree to state the wife was the home refinanced into her own name 12 months of the entry of the decree, and then she did not. The house should be sold, and the parties should equally divide any proceedings. Why it was approved refinancing one of the year entry dissolution of decree, which the bank now scheduling close refinance until 13 months after the entry of dissolution decree. Supreme Court affirmed, holding that because of the wife made of the fact and effort to complete refinance within the 12-month, husband and incur have the result of the delay of closing the sale of the house. Equal division of the proceedings was not required. Gleason versus Board of Equalization of City of Omaha, Nebraska. 302 Nebraska 869, citation April 12, 2019, Judge Michael G. Havican. Areas of law, government, administrative law, real estate, property law. Supreme Court affirmed a decision in district court finding that the lack of jurisdiction over assessment decision of Board of Equalization City of Omaha, Nebraska, exercising the squash judicial function as a result of appeals failure to file an appeal bond and city clerk within 20 days. Holding the statutory shim requires an appellate execute the bond, the city clerk within 20 days, and with the appellate did not, in this case, appellate originally appeared in a board to protest or propose special assessment and levy property. The board denied appellate protest. City Council of the City of Omaha, Nebraska subsequently levied a special assessment on the appellate property. Appellate appealed district court. The appellate had failed to comply with Nebraska Rev Stat 14814 by failing to appeal a bond by the city clerk 20 days, dismissing appellate appeal the lack of jurisdiction. Supreme Court affirmed, holding this district court correctly dismissed appellate court for lack of jurisdiction. And reinterest reality W. Citation 302 Nebraska 878. April 12, 2008. Judge Funky. Areas of law, juvenile law. Supreme Court from the order of separate juvenile court jurisdiction reality W as being habitable truant from school, holding that the statutory defense injunction under Nebraska Stat 79-209-2B